welcome to our webinar on estate planning. My name is Jim Kantowski, and I'm a co-founder of Bay Point Wealth in Annapolis, Maryland, along with offices in Asheville, North Carolina, and Sarasota, Florida. At Bay Point, we are committed to helping our clients with all aspects of their financial lives. And one of those aspects that we help clients with is estate planning. So today, our webinar is going to cover the basics of estate planning. We're going to cover what is estate plan, who needs an estate plan, why do you need an estate plan, and what are the basic components of estate plan. And to do that today, we are joined here today by our good friend of ours, Frank Campbell. Frank is a partner at Sims & Campbell in Annapolis, Maryland, and he's been a partner with us for a very long time. And he helps a lot of our clients with estate planning work. So I wanted to welcome Frank here today. Frank, how you doing?
I'm doing well, Jim. How are you?
I'm doing great. Thank you. You want to start out and just give me a little bit of background on yourself, maybe a little bit about Sims & Campbell?
Sure. So Sims & Campbell is what we call a boutique estate planning law firm, meaning, all we do is one area of the law, estate planning and estate administration. We're very disciplined about that. And the reason being is it's a complex area that includes, not just mastery of what kind of people know, trust law and obviously the tax code, but the human dynamic, the human element is probably the most important part of it, and probably the part that gets overlooked from attorneys that tend to not focus on this one area because they tend to focus on the documents.
Yeah.
But a good estate plan is one that not only saves taxes, but preserves relationships.
Yeah.
So we get better at that every day by focusing our practice in that one area and administering the estates that were put together years ago by our firm. So yeah. Sims & Campbell is a merger of two law firms. Mine, Holden and Campbell, that I took over from Ron Holden, which was started back in 1982. So we have a long history and a lot of clients where we've administered estates and learned from that. And Jane Sims had a very similar office to mine up in Towson. I'm in Annapolis, and we saw some efficiencies, and we complemented each other. Our practices were very similar in estate planning, but in the fine points, we saw that we complement each other. Finally, there's a real value for estate planning in longevity. It's not a transaction, right? A client who may be my age wants to know that when their plan is being administered, when they die, that we're going to be there. And if I'm a sole practitioner, they're going to be concerned that I've at least retired before them. And what happens to their plan? Who administers it? Who takes over? So by building a bit of a bigger practice, we now have 8 lawyers and a staff of about 25. We believe the practice will continue beyond any one lawyer and continue to serve the clients. So that was our main motivation for doing it.
Yeah, that's really important. My firm recently merged, and that was one of the main considerations too, is longevity. You touched on something, the emotional aspect of it, and that's probably from 2 aspects. That's number one. It's really hard to get people to sit down and actually create an estate plan because you have to talk about death. And then the other one is, when somebody dies and there's family involved, that gets probably very complicated, and you've probably seen some very difficult situations.
Yeah, you can't, I don't think it's wise to simply, pick the person you like the best or your oldest child to handle the important fiduciary roles. Sometimes it works that way, but it's not a pro forma list of names. I think a good experience in designing an estate plan would have a lawyer that would kind of inquire and second guess your first decisions and diagnose whether you're making the right decisions for the right reasons. So why did you pick Johnny as the trustee, right? A classic example I hear is I have 2 kids, Johnny and Joey. Johnny's fantastic. He's a Wall Street financier and wonderful guy. And Joey's struggling, maybe substance abuse, not a good spender. I'm going to give Joey's inheritance to Johnny and have Johnny manage it for Joey. Well, that's probably going to completely disrupt the brother relationship and cause them to go their separate ways personally. So even though Johnny's very capable of serving as that trustee, is that the best thing to preserve the family relationships? And I see that's a client's first instinct. And as I kind of learn about the family and the personalities and their needs, I would double back and ask, is that the best plan?
Yeah, perfect. So we got a little ahead of ourselves. So why don't we just step back and talk about what is an estate plan? What are we trying to accomplish with an estate plan?
Sure. I think with an estate plan, you're trying to accomplish clarity, efficiency, and preserve family relationships. I'll always go back to that. So what do I mean by clarity and efficiency? Well, we want it to be clear that our assets, right? We manage our assets while we're alive and healthy and able to do so. But there's two situations where we can't, right? When we're incapacitated and when we die. So in those circumstances, we want it to be clear who is in charge of managing the assets for me and who are the beneficiaries to receive them. Yeah. And if there's lack of clarity in any of those job titles or duties, there's going to be disagreement among the interested parties that will break relationships. So it falls back to that relationship piece again. So a good estate plan is one designed where you name the people you trust and have confidence in to manage assets in a crisis, incapacity or death, and then you direct who the next level of beneficiaries are.
Okay, awesome. So, estate planning is sort of helping you guide after you're gone, helping your relatives or heirs guide a transition in terms of how your money is going to pass.
Yeah, I think that's fair. And then there's layers to that, right? So when you think about the transition, this gets a little technical. So, change my direction if we're going too deep into this. But, one transition of assets after your death is through what's called the probate process. And that's a court supervised, I call it an accounting exercise. It's a very bureaucratic process where the government wants to gather up and see all your assets and make sure that your creditors are paid, your taxes are paid, and the beneficiaries are treated fairly, right? So before everything is done with your estate, making sure everyone gets squared up. Well, so it's not an inherently evil process. It has a good purpose, but it creates a lot of work and bureaucracy. It creates the opportunity for people to come out of the woodwork and file claims that may or may not be valid. And all this is done in a public process. And people these days especially value their privacy even after their death and the privacy of how their assets are passed to their beneficiaries. Sure. So sometimes people in an estate plan think, well, one of my other goals, in addition to just moving the assets, is to doing it in an efficient way, right? How can I reduce the public process, the expense, the time associated with administering my estate, the burden on my children? How can I minimize that by minimizing probate? And one typical tool is to use something called a living trust. That is a tool that is designed to avoid the probate process and allow your assets to transfer more efficiently. Another part of efficient transfer of assets, one that we think about a lot is, well, how do we transfer these assets to our beneficiaries and minimize taxes? Right? Sure. So that the wealth that you've earned, saved, and preserved continues to be preserved for children. And to be honest, these days when I talk to clients, often their main motivation is their grandchildren, because their children are already 60 years old. We're living so long. It's those grandchildren they care most about. So there's a lot of time and effort spent into managing and minimizing taxes associated with this.
Yeah. So who needs an estate plan?
I don't want to be overbroad, but an estate plan doesn't need to be a complicated thing, right? So when you say who needs an estate plan, I would redefine that to who needs to create this clarity, efficiency, and preserve family relationships when assets are transferred at their death, or who needs to make sure things are managed if they are sick and incapacitated. Everyone needs some form of a plan, and I think that's the right answer. Now, there are very complex plans where we have clients touching base with us every year and they're making gifts and creating complex trusts. And then there's folks that write wills that say, I give my assets to my spouse, and if she or he is not living, then divide it between my 3 children, and we're done. And a good power of attorney and the medical directive. It depends on what's important to you. It depends on what's in your estate. So there's a wide range of estate plans, but I think everyone needs some form of one.
And it probably depends on where you are in your life. I mean, so if you're a young person, you just have kids, the important piece of an estate plan is who's going to take care of those kids in the event that something happens to you.
Yeah, we feel strongly about that at our firm, and we see some differences of opinion when we see some work that clients bring to us from maybe other law firms. And here's what I mean by that. There are plans you create when you're young because your biggest concern is, oh my gosh, if I die in my 30s or 40s, right? Very tragically, very unexpectedly, I want to make sure that my spouse is provided for, he or she can continue to live in the home and raise the kids and educate the kids, and the fundamentals are in place.
Yeah.
And we're not dumping unnecessary complexity onto them. And then if my spouse and I both die, I want to know that my kids are being raised by the right people, that whatever inheritance they have is being managed by them and paying for things that are important, their education, not a Maserati. And that when they're 18 years old, they don't get all this money dumped in their lap because they're adults. Because I haven't really found many people, or maybe any people, that believe an 18-year-old is a financial adult, right?
Sure.
So design a plan where we wait until they're a little more financially mature before they receive their assets. So you can do that in a pretty simple will, power of attorney, medical directive plan. And academically, you can make an argument that anyone could use a trust or all these other tools that we use, revocable trust, to avoid probate. But I find for many kind of starter families, they're young and their financial savings are young. They haven't accumulated a lot. They probably shouldn't be investing a whole lot of money in a complex estate plan at that point. Even if academically there's an argument they can make it. My approach has been, and this approach has been developed because I've seen cases where one spouse with minor children has died. I've seen cases where kids have left as orphans, where both parents have died. And walking through that scenario with families, I see what's most important and what people want to have in place. And I see things that, academically may be nice to have, but at that, a tragic death of a 35-year-old, people aren't as concerned about. So don't overplan, don't overpay. And later in life, when you've saved for college and the kids are out of college and you're building your plan when you're in your 50s or 60s, maybe at that point we step back and take a more comprehensive look at it. And maybe at that point, you're in a position to pay a lawyer to create a more comprehensive plan.
Right. And when you're younger, I mean, a lot of those assets, they're probably fairly simple, and there's probably ways to transfer those pretty seamlessly without, will, like retirement plans and IRAs. It might just be the beneficiary that dictates where that money goes.
Right. Well, that's a risk with the young plans. You're spot on there, Jim. So, younger families will sometimes pull a form offline or out of a form book somewhere, and they think I have a will, and that's fine. I mean, this is what I do, so I could probably identify things I would do differently, but I try to be pretty pragmatic for folks.
Right.
The risk with those forms is these people have peace of mind. They wrote a will. They took care of their family. Well, as you just identified, Jim, where is a 40-year-old's most valuable asset? Maybe his house, probably his life insurance policy, and second is probably a 401k or IRA. And as you just mentioned, the 401k and IRA are not controlled by the will. They're controlled by the beneficiary designations. And if the beneficiary designation says it goes to little Johnny if my wife's not living, then we're back to the scenario I just talked about that we want to avoid. Little Johnny is going to get the IRA and the life insurance when he's 18 years old because you didn't direct it to the trust under the will.
Yeah.
So I've seen that. And I feel kind of bad for the folks that they they were kind of duped in a sense that they believed they did the right thing. They took care of the family. They wrote a will. But then the form they used or the computer program doesn't connect all the dots and tell them you got to update the beneficiaries to direct everything to flow through the will and the trust. So
Sure.
you got to
Sure.
watch that.
Okay. And then, so, like you mentioned, you get to a point where you've accumulated some assets and, you're maybe in your 50s and there's a lot, maybe more going on. And maybe there's second marriages, adult kids. There's, like you mentioned, substance use problems with kids. There's, kids getting started or spendthrifts. Yeah. And so those get more complicated to deal with probably when you're at that
well, sure. So the next stage in life, you've raised your young children, right? Now those young children are getting out of college, and the big trigger, a huge discussion we have is, well, who are they bringing into the family, right? Who are your children marrying, and how does that affect your vision for how your assets should be administered, right? So are you just going to give all your assets to your daughter because you know that her husband is going to work with her and manage them correctly? Are you concerned they might get divorced and he'll get half of what you leave for your daughter? Are you concerned that she might die and her will gives everything to her husband, who then gets remarried and maybe it doesn't get back to your grandchildren? So now some people are concerned and they're very concerned. They don't agree with the marriage decision one of their children made. Some people are not. And over time, every year, their in-laws become more and more their children, which is, how it ought to be, but as we all know, it's not always that way. So you want to think about that dynamic, and you can plan to ensure that the inheritance for your daughter is protected for her. Yeah. It won't be divided if she gets divorced. And when she dies, it's preserved for your grandchildren and doesn't necessarily go to the in-law. And this can be, you could, love your in-law and think he's a great guy, but you'd like to see your assets benefit your grandchildren. So there are techniques that we could use to build that into your plan. Typically, it's some form of a trust that gets created after your death for your daughter's inheritance to be administered in.
Mm-hmm. All right, so you've made it through two parts of your life successfully, or you've just made it, and now you're maybe getting older. What are the things to look out for, when you're getting up into your 60s and 70s? Is that changed the way you look at estate planning?
Yeah. So now we have a more definitive picture of who the family is, right? When your kids are 3, 4, and 5, you really don't have any idea, and it's more of a hope, and it's kind of hard to speak with clarity. Then your kids are in their 20s and they're married, but there's still now a whole new sense of lack of clarity. Okay, where is this marriage going? Who is this person that's brought into the family? How do they help or hinder my estate planning goals? And then as your children get into their 40s, there's a little bit more clarity there on what your estate plan looks like, what their life looks like. Even if the clarity is that child will always have uncertainty. Maybe that is the clarity, So at this point, what you're thinking about is, okay, let's take the information we have in front of us and guess less, make more definitive plans based on what our family members have demonstrated. So I think some of the fundamentals I talked about earlier. Okay, now let's talk about what can we do to ease the administration of your estate when you pass away, or make sure there's clarity if you get Alzheimer's and you're sick for a long time. Who is the person that's going to manage these things for you? How does he communicate with the other siblings? Who makes your healthcare decisions? Are the purse strings and the healthcare decisions people going to work well together, right? And then also, let's use this trust potentially, or joint ownership, or beneficiary designations, all these other techniques to get money to the beneficiaries more efficiently, more privately, more quickly, by avoiding what that is called that probate process. And then at that point, we're also got a good sense of your net worth, right? You're getting towards the end of your working life. You've demonstrated what your savings are. Bay Point's now showing projections where you're looking at the income that can be generated off of those savings and what your lifestyle is going to look like, and maybe what your net worth will be near your life expectancy.
Yeah.
And we want to take that and blend it with the estate tax laws. And that'll tell us, okay, how how do we want to plan to minimize estate taxes? You know, the federal estate tax rate as we sit here today, and these change constantly. They change as administrations change, but it's currently 40%.
Right.
So that's really high. And if you ignore that, it could take a significant portion of your estate. Now, the good news is currently each individual has, I'll call it a $10 million estate tax exemption. I said I'll call it that because it's adjusted for inflation every year. So technically it's about 11.5 right now. So someone whose estate is well below that probably has less of a concern for estate taxes. Maryland, if you live in Maryland, that exemption amount is $5 million per person. So some folks are well below the Maryland and they're safe from all estate taxes. Some folks are above the federal and they're looking at, you know, a 40 to 50% tax rate after you factor in Maryland.
Sure.
Some folks are, and they need to, maybe they're not worried about federal estate tax, but Maryland is an estate tax they need to plan for. And we have to decide how we build that into your plan to minimize those taxes.
How do you, with this election coming up that we have, there could potentially be some changes to the estate planning. How do you take that into consideration with an estate plan where it may not matter to you now, but a new administration changes and then those laws change? Are you constantly, I guess you're constantly updating plans for that reason, or are you preparing ahead of time for those changes?
That's a great question.
Make
the
projections
answer
of what's going
to
to happen.
all of them are yes. We do it all. But and what I mean by that is, you know, I don't think you want to overplan, right? So there is talk that if there's a new administration, the exemption amounts can be greatly reduced. Sometimes I think you have to wait to see how that happens. My experience in watching how estate tax laws are created is that it's political and it's blended with other congressional objectives, and so you really can't say, well, this looks logical, they'll probably do this, because you haven't considered all the other deals that are getting done in the way legislation gets created. Sure. So that tells me, and I've learned this through experience because the laws have changed radically since I've started practicing. We need to build flexibility into almost everyone's plan. We need to make sure that your plan doesn't become inadequate or wrong or trigger a tax simply because a tax law changes. So if the meaning of your documents change significantly while they're sitting in the drawer just because of a tax law that changes, to me, there's a lot of risk that when something happens to you, it won't work, it won't be out of date, you haven't contacted me again, we haven't updated. So I try to build in flexibility, and there's a lot of techniques we can use so that the structure's in place to minimize tax, but how we use that structure, how we implement the plan, we don't need to decide on until the first spouse passes away, until that time.
Okay, so you have flexibility in the plans, and then as laws changes, you can essentially potentially use the same documents that you have and just implement strategies to make sure that you're using your exemptions and your gifting and all those different things.
That's my best answer. Yeah, you know, when a client comes in to see me and the laws have changed, I'll look at their documents and say, you know what, we've built the flexibility in. Our discussion today is very different than it was 7 years ago when we designed it. But to be honest, the plan we've put together is flexible enough that it still accounts for everything we want to do. That's the good answer. Okay. Now, the other answer is, wow, this was written based on a formula and it was strictly related to the estate tax law in 1997 when you wrote this. And, you know, there was a $600,000 exemption at that time. We have to change these provisions and rewrite this because it doesn't work anymore.
Got it. So we're pushing, 25 minutes here now. Let's just touch on the basic documents, if you don't mind. So we've kind of been hitting on these things for a little bit. Maybe just go over if I come into your office and I need sort of a basic estate plan, maybe just give me a sense of what are the documents I need and some information around those documents.
Yeah. So we first have to decide what's important to you, right? And let's say what's important to you is kind of the most simple plan, and you're not as worried about avoiding taxes or even avoiding probate, and you just want a plan that clearly indicates who's in charge and who gets what. Well, to me, that's going to be a will, a power of attorney to manage your finances while you're sick, and a medical directive to manage your healthcare decisions while you're sick.
Okay.
If you have minor children, that will would include some provisions for guardianship, who raises the kids, and it would also include what's called a testamentary trust, a trust that gets created after your death, and the purpose of that trust will be to manage money for the kids while they're young. All right, that's kind of like level one, pretty basic planning.
So that trust is sort of written into that will, where if something happens to the parents and you have a 4 and a 5-year-old, there's protections and maybe there's people that are designated to manage that money as part of that trust in order to make sure it gets done properly.
Yes, sir. That's right.
The kids
right.
are taken care of.
So I think
you have this basic will in place, and then you've touched on trust and other things, and so they might come into place once you've accumulated some assets or things get a little bit more complicated.
Yep. So at that point, now you've got some assets. Maybe we look at this and say, is privacy more important to you? Do you want to reduce the level of complexity of administering your estate because your kids don't want to go through the work of probate or don't have the time because they're chasing their own kids and their own careers and all that? Is a revocable living trust a good part of your estate plan to make sure that we avoid the probate process? And then we would create the trust. It would say a lot of the same things your will said. Basically your assets go to your beneficiaries. But because the assets are transferred to the trust while you're alive, it won't be titled in your name, and therefore it won't be subject to probate when you pass away. It's kind of that simple. The trust while you're alive, understand, when you put assets in this revocable trust, you're not giving up any use, control, access. There's no tax consequence for the assets going in and out of these revocable trusts. From that perspective, they're very simple. They're a probate avoidance tool.
Perfect. We hear about trust often. I don't mean to interrupt you. We hear about trust often, and a lot of times it is this revocable trust, which keeps everything in your control. And then the other term, I think, is irrevocable trust, where you lose control of your assets to some extent. And that helps more from an estate planning purposes.
Right. So the reason why you would create an irrevocable trust while you are living is because you want to literally transfer the assets and give up some amount of use and control over them. And we spend a lot of time refining the edges of what use and control means. But by doing that, giving up some use and control through an irrevocable trust, you'd be removing assets from your taxable estate. So if the value of your estate is above those exemptions amount we talked about, you might say, I want to give $1 million into a trust for my grandchildren now, because I want that million to grow over the rest of my lifetime, knowing none of it will be subject to estate tax at my death. So that's typically where you see irrevocable trust used for estate tax planning and some asset protection planning.
Perfect. So the first thing you would do potentially is you'd look at a will. And then the next level of complexity is the revocable trust, which really isn't that much more complex. And then you have these more complex things which involve transferring assets.
Yeah, I think once you put the word irrevocable in front of everything, it gets a little more complex because it's much harder to change. It's much harder to undo. There are tax consequences immediately upon transferring assets to those trusts. So, we have to see the real value in those trusts. And there are, just it has to be for the right person. And you really have to have a long-term plan for what you're trying to accomplish there.
Yeah. So, and you've kind of touched on this in terms of your philosophy as a firm, but some people get over complex, some attorneys get over complex, and do you run into that often? And does that become a problem?
I see, well, first I'll say there are a lot of great estate planning attorneys in our community here. Many of them that I look up to that do great work. So, and then I see some cases where the documents are, they're complex because they're not clear.
Okay.
That's where the complexity comes in. It seems like it's a program that is written kind of the same for every person.
Yeah.
And it's hard to connect the dots on what's really supposed to happen.
Yeah.
That being said, I think a good estate plan is written very comprehensively, and some of the language is pretty broad. And the reason being is we're writing a plan that we will refer to and rely on 30, 60, maybe 80 years from now if there's trust for children and grandchildren.
Yeah.
And if we're very specific about what's relevant today, we will likely not be prepared for the unexpected contingency in 40 years.
Got it.
So we want broad powers and flexibility. And that causes people to say, oh my gosh, these things are long and somewhat complicated. And I agree, but I believe that's the right plan. And then I've seen it where it's overdone. It doesn't seem to be well thought out.
Yes.
And the other risk too, you just have to be careful about folks who are pulling forms off a shelf, right? Are you getting consultation? Is an attorney challenging your design features? If a client comes in and basically says, here's what I want, and the attorney's just taking notes and never challenges or questions or kind of make sure you've reframed things or spin an idea on its head a little bit, well, then you might as well fill it out online. You're just putting in your design idea. So I tend to believe I have some experience in design ideas that the client hasn't thought about.
Yeah.
So I just make sure that the client's plan is kind of proven to me.
Yeah.
And if not, we'll talk about it. Yeah. So I see that a lot too, where the documents are clear that, well, there wasn't real counsel or kind of experience shared.
Yeah. So you want to find an attorney that's really asking questions about your family, what you're trying to accomplish, and really.
Yeah, I kind of kid that you should be a little frustrated with your estate planning attorney in the first 20 minutes or half hour of the phone call, because people want to come in, and the first thing you want to do is get out of the lawyer's office, which I totally understand. You want to get this done and move on, and you want the lawyer to say, okay, here's what you need. Boom, 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 boom. How do you spell your kid's name? And you're out the door. Well, it doesn't work quite like that in my office, because I want to, before I tell you what you need, I want to diagnose a little bit about who you are and what's important to you. I want to kind of get a feel for, because when I say, oh, how are your children doing? The first answer is they're all doing great, and then, my son's 45 and he's living in the basement and he's on his third divorce and he's doing great. But okay, well, that tells me a little bit something about some of his decision making, his ability to manage money. People don't often disclose where there's substance abuse or mental illness on a quick question, right? They don't just give you that right away. So it takes a little bit of back and forth and diagnosis so that you can see areas where I need to pull the thread a little bit and explore. And if I don't go through that process, well, I could write a plan for someone you told me is doing great, when really he's kind of bounced in and out of maybe some substance abuse his whole life. That's something we see a lot of, and mental illness is undiagnosed and out there, and it can be incredibly disruptive and dangerous if someone that struggles with that all of a sudden gets a lot of money dumped on their life.
Yeah, absolutely. We're strong believers in really trying to get an understanding of what you're trying to accomplish, and so we appreciate that from you working with your clients. All right, so we touched on the will, the trust, and now the power of attorney you mentioned. Tell me a little bit about the power of attorney.
So power of attorney is it's literally just a document that says I designate my spouse and maybe my child as an alternate to manage my assets for me. Typically, we write it so that these agents have the authority to act now, knowing that they won't, but it avoids the cumbersome process of certifying that you're incapacitated before they can come alongside and help you. And most people say, oh, I want the document to say no one can do anything until I'm incapacitated. My experience has been, sometimes your family members don't want that in writing, either for a kind of emotional issue, or because there's some other things that they're trying to accomplish for you, and it wouldn't be quite as easy to do that if a doctor had certified you're incapacitated. And most people have a high degree of confidence in a small group of people that they could name these people as your agents and they'll act when they need to, and they won't when they don't. They don't need this layer of doctors certifying incapacity. So That's how I typically write the power of attorney. It's called a durable power of attorney. It's
Okay.
effective immediately, and it survives your incapacity. It continues to work when you're incapacitated. A springing power of attorney is one that is dormant now, but it springs to life when you're incapacitated. So that's the one that we'll do on occasion after we have a conversation, but I tend to lean towards the durable. They should be very broadly written. They should include a lot of powers. If you're trying to limit the power that you grant a power of attorney in a very significant way, I mean, there are fine points that we can talk about, but my question to you would be, are you choosing the right agent? Right? You want to find somebody you trust and then turn over the keys when you're not able to do it, and give them broad authority to act, potentially give them authority to do things you don't anticipate they may need to do right now. Because
Sure.
we all know over 20 years, life changes significantly.
Yeah, absolutely. Okay, so the power of attorney is really important in case something happens. You need somebody to sort of handle your affairs. A lot of people try and do that with like joint accounts and that sort of thing. Do you typically
Great point,
recommend that?
Jim.
What's that?
I said it's a great point. There's risk in that. So again, I mentioned that I try to be pragmatic. I get the idea of I want my daughter to have quick access to $20,000 or whatever the number is that's relevant to your estate for immediate expenses, maybe funeral expenses, and I want it to be easy. So I'll just make the account joint. Okay. But understand that if you name your daughter as a joint owner on a brokerage account that has $1 million in it, if that daughter gets into a car accident or gets sued because of a bad business deal or whatever else happens in life, which it does, those creditors are going to say that that's her asset because she's a joint owner and they want it. And whether or not you and your daughter win that argument, you will have many, many sleepless nights wondering how it's all going to turn out.
Sure.
And you've created all that risk just to simplify access to money that is maybe the difference between 1 day and 6 days after your death. The risk is not worth the reward in joint ownership.
Sure.
So I think it's okay for smaller accounts that you understand the risk, and if it happens, it happens, because it doesn't happen often, but it does.
Yeah.
But don't do your estate planning by joint accounts.
Got it.
There's a big risk there, and I've actually seen it backfire.
Okay. All right. So just real quick, we often have trouble when we're transferring accounts or using a power of attorney. They're not accepted by institutions. Is that sort of standardized now? Has that changed over the years?
Good question. So it is. Maryland passed a law in 2010 called the Power of Attorney Act, and the legislature created a form power of attorney, and we believe you should have that form. It's called the Maryland Statutory Power of Attorney, and the reason why we believe you should have it is because the law says if your agent presents that to Bank of America or Bay Point or a title company or wherever, that institution must honor it. And if they don't, they're going to be responsible for all the legal expenses getting it honored. So it gives you certainty, which you remember, that's one of the important parts of my plan, that when you're sick, your loved ones can step in and manage your assets without a lot of bureaucracy. Before this law was passed, my clients would go to Bank of America, present this power of attorney, and it would be rejected because they could. Right. And they'd say, the teller would tell the client, well, here, have your dad sign this power of attorney because it's our form, and then we'll honor it. And we'd say, the reason why we're standing here is because dad's incapacitated. He can't sign documents. We signed these 5 years ago for this purpose.
Yeah.
Incredibly frustrating. So this Maryland statutory power of attorney has solved that to a great extent. Now, the legislature wrote the power of attorney. So they don't always include every provision that I think is helpful to a family. They wrote it for every resident of Maryland, and they might be a little conservative about what provisions they decided to include in that statutory form. The law says we can't change the statutory form, so we also prepare what's called a supplemental power of attorney, a power of attorney that is includes all these other provisions that are what we call kind of sweaters in a suitcase. You go to Florida, you still throw a sweater in a suitcase just in case there's a cool evening, just in case there's an unexpected circumstance.
Okay, awesome. All right, and then the last one is the living will. Is that?
Yeah, living will, which is not a will, it's a medical document. A lot of people confuse that. Advanced medical directive, healthcare power of attorney, they're all kind of overlapping terms in Maryland. And that's a document that is critically important. It designates who makes your healthcare decisions while you're not able to. It also gives some guidance to your agents as to, your wishes with respect to courses of treatment, but mainly end of life decision making. Do you want to be kept alive on a ventilator and a respirator when there's no expectation of recovery? And incredibly helpful to your family to have that, so that they feel like they haven't guessed at what the right thing to do is, and when they tell the doctor to make this final decision, they are honoring your wishes and making your decision for you, not just kind of coming up with what they think you would want. So again, helps preserve relationships, because siblings can view this differently, and one of them may be in the position to make the decision. Provides clarity, because we all can look at it and generally know what mom or dad wants.
Sure.
So really important.
Sure. Yeah. I mean, when the siblings get involved, I mean, it can get difficult. So
This is an emotional time too, right? It goes back to the relational thing. So you have siblings or you have people who are kind of fact-based, and I forget if it's left-brained or right-brained, but they're kind of logical. And then other people, and there's nothing wrong with this at all, maybe they're driven more by emotions, or I've seen unresolved conflict with parents, and they realize I'm not ready to let them go because I'm hoping for the miracle so I can resolve this before they're gone.
Yeah.
So I've seen all of this, and the clarity is important.
Yeah. Well, Frank, thank you so much for joining us. We're pushing on 45 minutes here, so we're always grateful to work with you, and we appreciate your expertise. And Frank's always open to questions and just helping us out. So we're extremely grateful for that. You want to give a website if anybody stayed on here long enough to this point? Do you want to give a website out or something like that?
Yeah, sure. So the website is simscampbell.com, www.simscampbell.com. Sims is SIMS. My email is fcampbell@simscampbell.law, LAW, not .com. So if you have a question or want to touch base, that would be fine.
Awesome. Well, Frank, thanks again. I know you got to run. We always appreciate your time, and have a great day.
Thanks, Jim. Appreciate it. Have a great day. Bye-bye.
See ya.
See ya.